Hello and welcome back to the Ray Law Criminal Defense channel. Today, we're going to break down the concept of attorney-client privilege. When does it apply and when it does not? First, take a minute to click that subscribe button. Let's get started. Attorney-client privilege is the rule of practice that everything said between the attorney and their client is held in confidentiality. The attorney cannot be forced to divulge that information. It is a privilege that can only be asserted by you as a client. Anyone connected to you who speaks to the attorney cannot claim that privilege. You can speak to whomever you want to about your case, although this isn't advised. It is only your attorney that cannot. The rule applies not only to the attorney, but anyone under the attorney's supervision that is able to learn the confidential information by necessity of their job. So anytime you hear me refer to the attorney, know that their employees are covered as well. The attorney-client privilege kicks in as soon as you first consult with an attorney. They don't have to take you on as a client. Anything that is said during the course of a conversation to ascertain whether the representation is a good fit is covered by the privilege. Communications with your attorney where a third party is present are not covered. Thus, if you have a conversation about matters which you intended to keep confidential and a third party is present, the information conveyed is not protected. Also, the privilege does not apply if you give the attorney information for the purpose of committing a crime. An attorney cannot receive information regarding the planned commission of an illegal act. They have a legal obligation to report it to law enforcement. Attorneys must also reveal to law enforcement any information that is necessary to prevent death or serious bodily harm to a third party. Even when you are covered by the privilege, it is important to note the manner in which you converse with your attorney. For instance, typically any conversation that takes place over the phone line in a correctional facility may be recorded. Thus, even though the attorney-client privilege may prevent your attorney from revealing information, you cannot control who may hear it on a Department of Corrections phone. The information that was conveyed while the privilege applied is covered forever. This means that the attorney must keep the information confidential even after they are no longer representing you. However, once the attorney-client relationship is severed, any information communicated after that point is no longer covered by the privilege. Now, if you enjoyed this video, check out our Ray Law Criminal Defense channel for more information on what you can expect in your case. Thank you for the privilege of your time. We'll see you next time.